I don't like it. I don't like it. The fuck? Oh, I don't like it. Hello and welcome. Happy spooky season, everyone. Hope you're enjoying yourselves. Today we're gonna talk about McKamey Manor. Ever heard of it? My name's Leeja. I'm a real-life lawyer on a mission to demystify the law and how it affects your everyday life. That being said, I'm a lawyer, but I'm not your lawyer. Nothing that I say should ever be construed as legal advice, and you should always seek the advice of a licensed attorney before making any legal decisions. Turns out there's this haunted house somewhere, I don't know where. They require a 40-page waiver to be signed before you are able to enter the haunted house and participate, because it's just that ghoulish. I've been asked to comment on that waiver, so why don't we learn together? There's a gal by the name of Natalia Taylor. She's made two different videos on McKamey Manor, and I figure, you know what, let's learn from her. She seems to be a popular gal. Let's see what she has to say, shall we? Hi there, future Leeja popping in to thank the sponsor of today's video, me, announcing the launch of my consulting services. Okay, what does this even mean? Consider it like an hour-long gab fest, you and me. These sessions are meant for two different groups of people. Think of it as like two different branches. The first group, prospective law students. Are you thinking about going to law school and want to talk to someone who's been through it all? Are you confused as to the different careers that could open up to you if you got a JD? Do you want to know how to be successful once you start law school? Do you not even know if law school's for you? Let's have a chat. Second group of people, content creators. Are you new to YouTube and you want to know how to get started? Or maybe you've been on YouTube for a little while, but you're having a really hard time growing, and you want someone to come in who's been through it to help you figure out areas for improvement. I've been there, I want to help you. Or maybe you've been in the game for a while and you're finally ready to draft that first brand deal contract, or you want someone to review a contract for you. Or God forbid, your copyrighted material is being misused without your permission. I'm your gal. Check out the link in the description down below to see the various services I'm offering and set up a session with me today. Back to the program.
McKamey Manor, a Tennessee haunted attraction gone viral for its apparent 40-page waiver that allegedly states death is possible for its participants.
Very well leave McKamey Manor with bumps, bruises, cuts, or other possible injuries, including possible broken bones.
Famously known for being the most extreme haunted house that exists.
I don't like it. You guys, it's after dark.
Here is the guy that started it all. His name is Russ McKamey, also known as the owner and founder of McKamey Manor. Started his haunted attraction in San Diego over 10 years ago. He then moved the attraction from California to Tennessee, where it still takes place to this day. I tried to find out why Russ McKamey moved everything to Tennessee. I couldn't really find much on the topic. This entire experience takes place on his property behind his house. This is not a professional haunted house, okay? This is something that a random man decided to start doing. Not to mention, he doesn't even charge people to go through the attraction. Russ McKamey has stated on multiple accounts that all he charges for his attraction is a bag of dog food.
So the non-payment thing is interesting to me because there's this kind of general concept in property law. It depends on what state you're in, but it's pretty universal, where when you invite someone onto your property for the purpose of making money or having a profit of some sort, you have a heightened duty of care that you owe to the people that come onto your property. So if there is anything on the property that could be dangerous, that someone could hurt themselves on, you have a duty to warn them, but also to fix that problem. You don't have that duty if you're just having like guests over, but if you have people over and you're making money, there's a heightened duty there. So maybe he's trying to get around that property law thing by saying, well, I'm not inviting them over for profit. We're just all friends hanging out. But then there's also the issue of like, if he were a business, a for-profit business, there would be like business regulations involved, which I think are not involved here because he's technically not for profit. But that's my theory. Probably because having people on your property to make money off of them comes with a heightened standard of care that you owe them. And then also probably just like business laws in the state. That's probably why he moved out of California too, because I'd imagine California probably has some different, maybe more stringent business laws than, where did he move? Alabama? Something tells me the ideology of Alabama is like, whatever you do on your property is your business, mister. You know what I mean?
What happens if someone dies during their tour? A waiver won't mean anything. We have had one heart attack, for real. 7 years ago we had a heart attack. It's good stuff.
A bunch of people have come forward about their personal experiences at the manor and describe it as something of their nightmares, something that they will regret for the rest of their lives. A lot of people were left with physical scars, like teeth being pulled and women getting all of their hair cut off, but others describe the experience as emotionally scarring, so much so that they've developed mental disorders and have to go to therapy sessions and need to seek treatment because of what they experienced at the manor. And I am not kidding you when I say people are leaving this experience with actual trauma. Now, I know to a certain extent, what can you do? These people signed up for this. They signed the waiver. You can say they knew what they were getting into. So at what point do you take responsibility as a participant? Do you think these people are responsible because they signed up for it and they filled out the waiver? Or do you think Russ should take some responsibility? I will also leave a link down in the description for the McKamey YouTube channel if you would like to do your own research. I'm warning you, this stuff is very graphic.
Don't think I'll be doing that. Is Lady a news anchor? Because I think she'd have a very successful career if she wanted to be. She made 2, remember? Let's move on to the next one. These both have like 1 million plus views, so y'all seem interested.
I believe they were part of a CIA project called MK Ultra.
MK Ultra.
MK Ultra?
They hypnotize you to make you even more scared? I don't even know that much about it.
I don't like it. I don't like it. I don't like it. The fuck? I don't like it. Oh, I don't like it.
If you haven't seen my first video, bitch, I highly recommend you watch it.
I watched.
If you make it to the end, there's a $20,000 reward, which in itself is kind of wishy-washy. He owes like a shit ton of money to the state of California in unpaid taxes, so I have no idea where he got $20,000.
Oh yeah, this guy's a libertarian.
Now, I do want to emphasize, like my friend Julia already said in her video, these are all allegations. We never want to spread misinformation on this channel or on YouTube.
Good thinking, girl. No one wants a defamation lawsuit.
I decided to do a little bit more research on the dark web about McKamey Manor, and here's what I found.
Sorry, I'm just trying to imagine this like cute girl in pigtails doing dark web research. God bless. I love it.
In the 50s, the United States government took its own citizens and dosed them with a shit ton of drugs in hopes that they could figure out how to program people. In other words, brainwashing. Yeah, and now there's all these sources saying that over at McKamey Manor, the little torture chamber that we were discussing a couple months ago, they're practicing MK Ultra experiments. Now we have people saying that they were drugged when they went through McKamey Manor. Once you're under the influence, you can't consent to something anymore. That waiver that you signed is no longer valid because you're not in the right mind. That waiver that you signed doesn't matter. It's voided. You can technically take legal action. That contract that they signed may or may not have had an NDA, a non-disclosure agreement included, where it states they're not allowed to discuss what goes on behind those walls, therefore leaving people to feel alone and that they can't even legally talk about what happened to them, which isn't true. I will say once again, these are allegations. No one ever wants to spread false information. Russ McKamey of McKamey Manor is a monster.
I will say, as much as it's easy to say, like, these are all allegations and we don't want to spread misinformation, I would caution on then going on to say, like, he's a monster and needs to be put behind bars. You know, like, defamation is a tricky little bugger. And it's best to err on the side of always saying allegedly before everything, unless it's been proven in a court of law. Anyway, I digress. Okay, fascinating. So I got my hands on a version of this 40-page waiver. It's an old one, apparently. Moira, I'm trying to do my job. Okay, so there is a non-disclosure agreement in this version. Hi, baby. Come here. Come in. Hold on. Let me put my glasses on. These are from Warby Parker, by the way. A lot of you have been asking. So there is a non-disclosure agreement in this version, which looks like it's maybe from 2017, but who's to say? Moira is going to town on her bones, so I'm sorry if you can hear grunts, but it kind of adds to the spookiness of this video, so frankly, you're welcome. Okay, so there's a non-disclosure agreement. Certainly people who signed this would assume that they're not allowed to talk about it, but there's also a non-disparagement agreement. That has a paragraph that says, participant agrees that during their tour of McKamey Manor and for 20 years after their departure from the tour, the participant shall not, through any form of communication with the press, public, clients, media, blogs, or social media, disparage McKamey Manor in any way. Yikes. This waiver that I got my hands on is only 23 pages long, so I did not get my hands on the original or the current 40-page waiver. I believe you have to become a participant to get that. If you have it, send it my way, but we at least have a form of it. And now there is, like she said, a couple provisions here that seem on their face to be a bit spooky. For example, express assumption of risk of inherently dangerous activity. Participant agrees and understands that participation in this event is both physically dangerous and could have a negative impact on one's mental health. By signing this agreement, the participant expressly assumes all risk of physical, mental, or bodily harm despite this acknowledgement of the known risks. And then accidental death and disability and other medical insurance. Should any medical emergency or otherwise treatment be required, I understand and agree and represent that I have my own medical and or health insurance that includes both accidental death and disability insurance. I agree to pay all incurred expenses that may result of my participation and expressly agree to pay all costs. Okay, then it also says, by signing this agreement, the undersigned agrees that he or she does hereby voluntarily release, discharge, waives, and relinquishes any and all activities or causes of action for personal injury or loss of my property, property damage or wrongful death occurring to him, herself, arising as a result of engaging or receiving instructions in said activity or any activities incidental thereto. This thing was not proofread. Okay, and then in all caps, it is the intention of participant by this instrument to expressly assume all risk of such personal injury, death, or property damage upon him or herself to the exclusion of McKamey Manor and to exempt and relieve McKamey Manor and all of its actors, no, not supposed to be an apostrophe there, from liability for personal injury, property damage, or wrongful death caused by negligence. Now, okay, so this seems extreme. This seems spooky, right? Like, oh my gosh, they're signing away like they could not be held liable for someone's death. Unfortunately, or fortunately for businesses, I guess, this is not uncommon. This is not an uncommon thing to have in a waiver. Think of any inherently dangerous activity that one might partake in. Downhill skiing, snow tubing, snow sports in general are a big one. Going to a theme park, for example, riding on roller coasters. Inherently dangerous, that's why I never do it. So I looked at a couple other waivers just for reference. I looked at one for the largest water park in America, which is called the DreamWorks Water Park, and is attached to a Nickelodeon universe, which is wild because the Mall of America in Minnesota, where I live, also has a Nickelodeon universe, and frankly, I'm insulted that they're also consorting with New Jersey, but I digress. So I looked at the DreamWorks Water Park, which, like, water park, inherently dangerous. Water, keep me out of it. And then I also looked at a local snow tubing place here in Minnesota, just like your run-of-the-mill, small, local snow sports place. I've linked both waivers down below so you can compare yourself in real time if you'd like. Both waivers very clearly state that the person signing waives their right to hold the attractions liable for anything, including death, even if the attraction or its workers were negligent. So even if the attraction acts negligently or one of the employees does, you still can't hold them liable if you die or break a leg. Like, say an employee spilt some water on the tubing track and it's iced over, creating this slick that sends you flying. You fall back, you crack your skull open, can't hold them liable. Sorry. And generally speaking, that's completely in line with the law. It is, we've determined as a society, completely acceptable for businesses to have visitors sign waivers that waive liability for negligence, even in the case of extreme bodily injury or death. And I guess we have this in place because it allows businesses to flourish without pesky litigation and costs. But then there also is, on the other hand, this argument that people are assuming risk. They're signing signing up for it. You know when you're going skiing that you could be injured or you could die. However, most states have exceptions to this ability for attractions to waive their liability, and those exceptions require that the waiver is very clear. It can't be in some fine print, it can't be, hidden somewhere, it has to be clear. And most states, including Tennessee, where McKamey Manor is located, do not allow businesses to waive liability for gross negligence, which is like negligence that is worse than regular negligence. If you saw my last video, which was also a spooky season video, I reacted to the exorcism of Emily Rose, where we talked about criminal negligence. This is a similar concept. So with regular negligence, the standard is that the business in this case has to act reasonably under the circumstance and take reasonable care in protecting visitors. So like if there's a metal pipe sticking out of the ground, it would be reasonable to put a cone over it. If the floor is just mopped, it's reasonable to put up a wet floor sign. See what I mean? You have to take reasonable precautions to protect your visitors, especially, like I said earlier, if you are making money off of them. You owe people a duty to check the premises for potential dangers and to correct those dangers when you open your property up for customers. However, businesses are allowed to have you sign this waiver so that they cannot be sued for things that they reasonably should have protected you from, like a wet floor. For example, in the case of a water park, maybe accidental drowning or going down a slide and hitting your head on the slide as you get shot out of it, or all the other myriad dangerous things that could happen if you go to a water park, which you should never do. These are reasonably foreseeable things that under regular circumstances, the park would have to warn you about or protect you from. But when you sign a waiver, you say that even where it was unreasonable for the business to not have protected you from a known danger, you still can't sue. However, if the business is grossly negligent, they usually can't avoid liability by just having you sign a waiver, including in Tennessee. Gross negligence is where the business doesn't take any precautions or care at all. Like if they just let their water park go into disrepair, like they don't clean the water, don't maintain the slides, and it's not structurally sound, and then a slide collapses or someone gets dysentery, that could be argued to be gross negligence. Gross negligence can also mean an extreme departure from what a reasonably careful person would do in the same situation to prevent harm to oneself or to others. The key question being, what would a reasonable person do in this situation, and how extreme was the business's conduct in relation to that standard? I think it would be pretty easy to argue here that the activities, at least based on what I've read, that have been alleged to have occurred inside McKamey Manor. I read, for example, that people that work at McKamey Manor, Russ told them, like, just try not to kill them. And they didn't have any training, and they didn't have any rules, and there was no safe word for a while. Though now there is a safe word, but like, is it followed? I've heard no, I've heard it's not respected. All of these things, I think, could easily be argued rise to the level of gross negligence, such that a waiver like this could not be enforceable. There's also this really interesting concept that I read, I think, from a woman named Danielle Citrone. She is a scholar and she's badass. She writes about how consent and the law is murky when it comes to assault, especially sexual assault, but I think it applies here, and here's why. Law has a really hard time thinking about consent as a thing that can be given and taken away when it comes to assault specifically. So we say, well, they consented to it, so she wasn't raped. Or, well, they consented to it here, so like, it's not assault because they consented to being abused. Which, fair. There's a certain amount of assumption of risk that we allow in the law. You assume risk when you sign up to go to a haunted house. Not so when it comes to like sex and assault and stuff, but when it comes to signing up voluntarily for a haunted house where they say like, there will be physical contact and you could get hurt, some of that does lie on the shoulders of the participants, yes. However, the idea of consent that the law gets so wrong when it comes to assault is that consent can be revoked at any point. Like if you are entering into a sexual encounter, you can revoke consent. You can decide, nope, I no longer want to participate at any moment. That is a valid form of consent, and that is a valid revocation of consent. But when it comes to contract law or assault, the idea of revoking consent is like foreign to the law. However, when it comes to property law, consent is like pretty easy to understand. I'm allowing you to use my property, but now I no longer want you on my property, and I don't really have to explain myself. I can just tell you to get off my property because it's mine. Where was I going with this? Anyway, my point being that just because they signed this waiver and they signed up for this horrific haunted house that if you do any research on, you should be able to tell, like, it's gonna be bad and you might experience trauma, that doesn't necessarily mean that that consent shouldn't be allowed to be revoked via, for example, a safe word, which they apparently do not honor. So I've heard, allegedly, even though they now have a safe word where before they did not. And then she also makes a really great point. Good job, Natalie. Are you a lawyer? Do you want to become one? Or a news anchor, like I said, because you have a great voice for it. Anyway, if you are coerced under extreme duress to enter into a contract, it can be voidable. And if you sign a contract while you're under the influence, that can also be voidable. I will note, this is something that is like seems like a lawyer technicality, but it does matter. It's not voided, like she says, because they signed it allegedly while on LSD, or because they were under duress, like because he'd started torturing them and then had them sign this contract. It's not voided automatically, it's voidable. And it's an important distinction, because if it's voided, then the contract is gone. If it's voidable, that means that they have to go in front of a judge and argue whether or not it should be voided, and there's some weighing that has to come in. So if it's, for example, they're gonna argue like I was under the influence of a drug when I signed that waiver, then they would have to argue in front of the court like, how much influence did this drug have on you? And then they have to answer the question whether or not the person who signed the contract knew what they were doing when they signed it. So if it's like a microdose of LSD, there could be arguments saying like they knew what they were doing, and there could be arguments saying they knew well ahead of time what they were doing. I would be interested to know when they see the waiver. Like, do they see the waiver for the first time when they're in the mud being actively beat up and forced to sign, or do they get a copy sent to them ahead of time? Because whether or not a person has an opportunity to seek legal counsel before signing a contract can come into the argument as to whether or not it's voidable. However, I would argue probably if I was in Russ's shoes that they can read and that the wording in the contract is very clear what they are signing up for. Just playing both sides here. Because as a legal person, you have to be able to anticipate the other side's arguments. There's also some like public policy arguments that could be made against the enforcement of this contract, like saying that the object of the agreement is illegal or against public policy, meaning like they're agreeing to being tortured and they're agreeing to allow this man to torture them. And just as a public policy argument, we don't want to allow contracts where people are agreeing to be tortured to be enforceable, therefore it should not be enforced. I think there's a lot of stabs that could be taken at this contract to get it voided entirely. The reason why you would do that is then you would argue, I'm going to sue him for intentional infliction of emotional distress, for negligence, and I'm gonna get him to pay me for my suffering, my pain and suffering and my damages if I lost wages because I couldn't work or something. And I am going to sue him this way because I can, because this contract isn't enforceable. So even though this contract says that I can't, it's not enforceable. Also, it seems like a lot of people are coming out in against him and speaking out about their experiences, and I wonder if there's been many lawsuits. Let me just see, what's his name? Russ McKamey? It's supposed to be Russell, huh? Russell McKamey. Nothing. Interesting. I mean, I'm not finding anything in a cursory search. I mean, we have like victim speaks out, there's a petition, not seeing anything. But just theoretically, if the allegations against him were true, what crimes could he be tried for? Let's look into Tennessee torture laws. Weird search history here. Just looking up torture laws in Tennessee. I mean, aggravated assault, probably, right? So an aggravated assault, as defined in Tennessee, a person commits aggravated assault who intentionally or knowingly commits an assault, and the assault results in serious bodily injury or death, or involve the use or display of a deadly weapon, or involve strangulation or an attempted strangulation. You could pretty easily get aggravated assault. Probably false imprisonment. A person commits the offense of false imprisonment who knowingly removes or confines another unlawfully so as to interfere substantially with the other's liberty. I'd say those two would be pretty easy to get them on based on the alleged facts in this alleged case that we don't know are true or not because it's never been held to be true in a court of law. Fascinating. Horrifying. Have you ever participated in this haunted house? in McKamey Manor, I would love to hear from you in the comments below. How you doing? Anyway, to sum this all up, it's questionable as to whether this 40-page waiver would be able to be held up in court, but someone would have some very viable arguments as to gross negligence on the part of the business, which this would still be considered a business because they're inviting people on their property and they're getting dog food in return. So I think that they would have an argument that this is a business, that they're inviting people on for profit. How much money do you think they're making off their YouTube channel where they show these torture videos? And that they committed gross negligence towards these people while on the property, that the contract is not enforceable because it was entered into under duress or under the influence, potentially. But I would say that Russ would have some arguments saying that they entered into this knowingly, they knew what they were getting into, it is a standard waiver. He seems to also argue a lot that they're not actually being tortured, that there's some sort of mind trick, MK Ultra or otherwise, that's being tricked into making them think that they're being tortured. I'd be interested to see him try to prove that in a court of law, but who knows? This was fascinating. I hope you enjoyed finding out about Tennessee law. Sorry, Moira is snoring so loudly next to me. It can't be stopped and nothing can be done. Thank you once again to the sponsor of today's video, me. Click the link in the description down below to check out the services I'm offering and set up a session with me today. Thanks so much for watching. Don't forget to like and subscribe if you found this video informational or entertaining. Hope you have an excellent spooky season. Bye-bye!